One of the most typical problems that we run into will be a supported spouse who comes to your office and says, you know, my husband or my wife found out that I don't want to be married anymore, and he or she is saying, I am no longer going to support you. I'm not going to pay your bills. I'm not going to pay the mortgage on the house. I'm not going to take care of any of the financial obligations that I've had and that I took care of throughout the course of our marriage. So what do? The answer is it's really not complicated. The first thing you do is once you get into the case, you contact the other attorney and you say, you know, we had a status quo established during this marriage. We want to reestablish the status quo and we want to keep it in place for a reasonable period of time, at least until we can exchange financial information and find out what the temporary support arrangement should be. Now, if the other side says no, or if you have a spouse who's not represented by counsel and they simply refuse to pay support, the answer is you file what's called a motion. A motion is a set of papers that you prepare and you submit to a judge. Once a complaint is filed, the court has jurisdiction over your matter, which means the judge now has authority to enter what are called orders, which compel parties to do certain things. So if you get an order entered and it says that your spouse must pay your bills or must give you direct support or must pay child support, that order is enforceable, and that's how you go about collecting the support that you're entitled to.